Three of the four abstracts that we submitted for this year's IMIG meeting in Cape Town were accepted for poster presentation. The fourth abstract, which was accepted, led to an invitation to me to actually give an oral presentation during the seminar itself. It's on the subject of changes in the U.S. bankruptcy trust fund system for asbestos and mesothelioma claimants. I presented much of this data in 2012 as a poster, but this year the update will be given as an oral presentation with PowerPoint slides. Our firm is involved in virtually every asbestos bankruptcy. There have been so far some 80 companies that have filed for bankruptcy reorganization in whole or in part as a result of asbestos claims. 50 of them have produced asbestos trust funds, and some others are in the process still of being reorganized. I and one of my partners have been involved in virtually all of these bankruptcies, working on the reorganizations themselves, and then later, once the trust fund is established, serving as members of a trustee advisory committee that works with the trustees to manage the funds and administer the programs that lead to compensation of patients. As a result, we've been involved in more asbestos bankruptcies that in turn involve more money than any other law firm in the world, and have developed a lot of expertise on this subject. The 50 or so trust funds that have already been established have paid out about over $20 billion in claims to asbestos victims and have another 30 billion plus remaining to spend in the future. The majority of these funds go to mesothelioma patients and their families. These trusts are responsible for the asbestos liabilities of the companies whose money funded them, no matter where in the world the asbestos disease takes place. As a result, people anywhere are entitled to make claims if they can meet the criteria that the trust imposes. For mesothelioma patients, that involves a diagnosis, proof of exposure to the asbestos products for which that trust is responsible, and a demonstration that the claim is valid under the law where the person lives or was exposed, and then some evidence of how that claim would be valued in that jurisdiction. So if somebody worked in England or Germany or Australia or Nigeria and had asbestos exposure to a particular product, they can attempt to demonstrate the value of their claim, and if they can do that, the trust will pay them. Of course, it's relatively easy to prove claims in the United States because the trusts have themselves acknowledged that they have had asbestos products in a great many places. Altogether, over 100,000 work sites have been identified by one or more trusts as areas for which they accept responsibility. On the other hand, there have been something over 3,000 foreign work sites that have had the same sort of recognition. In addition, many of the asbestos products were designed for use on board ship. Obviously, ships can go anywhere in the world, and there are over 19,000 ships that one or more trusts have recognized as places on which they have liability for asbestos exposure. In addition, people can prove claims even if the sites are not already listed. During my talk, I will review this information and focus a little bit on how doctors from all over the world can help their patients access these funds.